In the case of state of Jammu and Kashmir, I also submitted that it was only instrument of accession which was executed between two entities, the Dominion of India and the state of Jammu and Kashmir. Making that as the base, that would be the relationship between the Dominion of India and this entity. Subsequent to this, when the residuary sovereignty vested in the king, further documents were to be executed relating to this particular state. The Maharaja issues the proclamation of 1948. In that proclamation, he says that we need to have a national assembly to frame a constitution. This is the genesis of framing of the constitution of Jammu and Kashmir is rooted in the nature of instrument of accession as well as the proclamation of 1948. That's where we arrive the source as to why second constitution for the state. Then the third thing is that after these declarations are made and no further documents are executed, but at the same time the Constitution of India was being made. So the problem and the issue, the question before them was what is to be done. This is what I said yesterday. And I also submitted that meanwhile, some more developments had taken place, which had an external dimension, which also shaped and influenced the Constitution Assembly of the Union of India. Now, this is the whole scenario which existed before Article 370 was adopted. And I also submitted that the residual power came to be subsumed by Article 370. My Lord's observation was what happened to instrument of accession. But subsequently, when you agree to a constitution, you had acceded to the Dominion of India, maybe partly only, may not be fully, you had not integrated, I would say, because you had not executed merger agreement. So the Article 370 subsumed this remaining power, whether we call it sovereign power, residuary power, but it retained the power with itself. And therefore, next question would be the exercise of this power. Whereas the power is there in terms of the instrument of accession, now in Article 370, how it was to be exercised. I will make a digression here. Perhaps at that point of time, it was felt that since we don't have a Maharaja any longer, we don't have any other authority to do it, who would go in almost like a substitute for merger agreement? If complete integration had to take place, how could this be brought about? A mechanism is evolved in 370 that will be entirely for the people of Jammu and Kashmir to integrate with India. Whereas they have done it with accession, they have acceded to Union of India, but to integrate it completely, as I said, shaking hands and embracing, the embracement was left to the people of Jammu and Kashmir, but in accordance with the mechanism and the procedure prescribed by Article 370. What kind of power the Maharaja has retained? Most important was the power to make laws, which I said yesterday. Therefore, Article 370 itself says all of the provisions of the constitutions are excluded. Notwithstanding, all provisions are excluded, except Article 1 itself and Article 370. Everything else is excluded. Nothing else applies to the state of Jammu and Kashmir. The first part, as I come to that, I'm just developing this point for lots of consideration. The first part of Article 370, application of laws. In list 1, could be list 2, list 3. It talks of application of laws. Now that application of laws, subject to one condition, that since I had donated some power earlier under instrument of accession, on 26th of October, like defense, communication, foreign affairs. So there was no further donation required. Therefore, the word consultation was mentioned. Simply consult. Consult does not mean agreeing. You just have to talk to somebody in normal language also. The consultation, you talk to somebody whether he agrees or disagrees, but the dominant person would go in his own way after talking to him. But for application of it, the word concurrence was required. Now, there's a fundamental difference in consultation and concurrence, where both have to be ad idem, both have to agree. When both have to agree, they have to agree in respect of the entry under which the parliament had the power to make laws. But at the same time, you cannot have an extension of a law made by the parliament unless the relevant supporting provisional constitutional entry main provision is also made applicable. It is not conceivable that the parliament would have a law A, but there is no supporting provision of the constitution applicable to the state of Jammu and Kashmir, which would support extension of that law to the state. Limitations provided in 370 itself with regard to the power of the parliament to make laws for the state of Jammu. First limitation was if you are relating any subject to list 1 or list 3, which is not a subject covered by instrument of accession, then you need concurrence of the government of the state. Concurrence of the government of state would mean, in simple language, concurrence of the people of the state through Council of Ministers. Why was this needed? More on the question of why of Article 370. Why so special provision for state of Jammu and Kashmir? Only for one simple reason, that there was no merger agreement. That's the most important fact in the whole case. And therefore, this autonomy had to be maintained. The state found a way to maintain its constitutional autonomy by restricting the power of the parliament to make law, both in respect of various entries as well as in the substantive provisions.
Yes.
Even with regard to this, the substantive provision of the Constitution of India, which was to apply, there is further restriction in that. It again has to be done with the concurrence of the government of the state. So there are two places. One, when you want to apply any entry, you need concurrence. When you want to apply any constitutional provision, you need concurrence, except in respect of what is mentioned in instrument of accession. Support my point by the very text of Article 370. It mirrors what in simple language it says is that if what is mentioned in instrument of accession, somebody will have to agree entry mentioned in instrument of accession corresponds to any of the matters in the union list or concurrent list, and the President of India is to declare that such an entry corresponds to that list, then only the Dominion legislature will have the power to make the law. It is not straightway that we agree to the entry and they extend the law. It has to be in consultation, and the President has to almost declare it that it corresponds to the matter specified in the instrument of accession. For that consultation, the government is required. So it means it involves the President of India on the one side, and second is the government of the Jammu and Kashmir. Two are involved in this, government of the state. And then the third constitutional authority is the President, who is to declare that this matter specified corresponds to the subject of instrument of accession. Now, this is only in respect of union list and concurrent list. So this is another limitation with regard to the power of the parliament to make law. Why is this? What is the need of this? Parliament has the plenary power. They can make any law under list 1 and apply it throughout India. Despite having acceded to the Union of India, despite being a part of Union of India, the mechanism was different only because it had subsumed the residual authority which the Maharaja had. Now this carves out the space for what we are contending here, why we are before the Lordships. What is the whole case about? We're taking Lordship's time, the 5 learned judges are hearing this matter. It's only because we believe that we had constitutional autonomy. Under the Constitution of India itself, certain autonomy was available to the state of Jammu and Kashmir, which was taken away on 5th and 6th of August. We're here contending that you cannot take away that autonomy of the state. This is all what the whole case is about. Now, I'm trying to lay down the basis. Where does this autonomy come? This autonomy comes from 3 instrument of accession is 1. And second important thing is Article 370 itself. It doesn't give power to the institution of parliament to make any kind of a law it wishes to make for the state, unless the state government agrees to it. And both by consultation and concurrence. Now, this part relates to the constitution itself. The earlier part relates to the lists. That's the power to make the law. But this clause D does not talk of the power to make law under the lists. It talks of the provisional provisions of the Constitution of India as such. giving power to the president, you apply the provision of constitution side. But in order to maintain the constitutional autonomy, power is also given to the government of the state, that you can request the president, please apply this provision with this modification, with this exception, with this omission. How that is to be done, that is between the two governments. That's between the government of the state and the federal government, the central government. That's between them. That could be a political decision with which the court is not concerned. But constitutionally speaking, there is no power vested in central government or in president to make any law as they wish, as they do it in the case of other states. No consent is required from the other state. No consultation is required from any other state. No concurrence is required of any other state, except of one state, that's state of Jammu and Kashmir. This is the second part which will demonstrate to us that how the constitutional autonomy of the state is embedded in Article 370. So concurrence is needed for the application of these constitutional provisions. They may as such apply entirely up to the two governments to agree to that. They may apply with the modifications entirely up to the two governments. They may apply with exceptions entirely up to the two governments. While it is in the process of framing the constitution, then you will have to place that concurrence before that constituent assembly and with jurisdiction on the constituent assembly to agree or disagree with that concurrence. That is what is significant. For such decision as it may take thereon. So in real practical terms, up to 1957, when the state adopted its own constitution, during that period, if at all any concurrence at any state or any consultation at any stage had been done, it was to be placed before the Constituent Assembly of the state. And what's important is that the Constituent Assembly of the state could invalidate that concurrence or that consultation when it says, for such decision as may take thereon. When we read this clause, this is different from the clauses which are preceding it. And this clause carves out a position for itself when it says, notwithstanding anything in the foregoing provisions of this article, which will be the earlier, the union list, the concurrent list, consultation, or the provisions of the Constitution. Notwithstanding that, the power is given to the president to, this is one of the issues involved in this case. Can we say he has de-operationalized it or has he amended it? The expression used is declare that the article shall cease to be operative or shall be operative only with such acceptance. So the president is given the power to de-operationalize this article. Therefore, a distinction between Article 368, which my lords observed, that had nothing to do with 370. It's a case of de-operationalization of Article 370, subject to the method, the mode, and the requirement of subclause 3 of Article 370.